Hello everyone and a warm welcome to this insightful course on intellectual property rights, infringement in cyberspace, a cyber law approach. In this, I will be dwelling into how traditional principles of intellectual property are being tested, redefined and sometimes even challenged in the virtual world, a world without physical borders and yet governed by global interactions. Let us begin with a brief overview of what this course seeks to address and why this holds immense significance in the present digital era. We live today in an age that is often described as an information age, or we can say digital era, where data has become the most valuable resource. Every aspect of our lives, communication, education, commerce, entertainment, and even governance has become increasingly dependent on digital platforms. This transition from a tangible paper-based world to a digital borderless ecosystem has not merely changed how we share and consume information, it has redefined how we create, own, and protect intellectual property. The ability to produce, store, and distribute creative content online has democratized innovation. Anyone, anywhere can become a creator. However, this openness has also brought unprecedented challenges. In cyberspace, ideas can be copied, altered, and disseminated across the globe within seconds, often without the consent of the creator. Thus, the need to study intellectual property rights (IPR) in the context of cyberspace is more pressing than ever. The digital transformation of society has made intellectual property both more valuable and more vulnerable. With just a few clicks, a copyrighted song can be duplicated endlessly. A brand's logo can be counterfeited on a website, or a research article can be plagiarized using sophisticated AI tools. The internet, while being one of the humanity's most significant inventions, has also become a breeding ground for unauthorized use and exploitation of intellectual creations. What makes this situation more complex is that such infringements often occur across the jurisdictions. An infringing act may originate in one country, be hosted on a server in another country, and have an impact across several others, raising intricate questions of jurisdiction, applicable law, and enforcement mechanisms. The topic we are going to explore is IPR infringement in cyberspace. Is therefore not merely a niche area of legal study, but a critical issue that affects economies, business, and individuals worldwide. Intellectual property rights serves as an engine of innovation, incentivizing creators and by ensuring that their intellectual labor is recognized and rewarded. In a digital economy where the line between the producer and a consumer is increasingly blurred, these rights provide the necessary framework to maintain fairness and accountability. Yet, the borderless nature of cyberspace often challenges the very foundations upon which traditional IP laws were built. Most of our legal systems were designed in an era when inventions were tangible, works were physically published, and infringements could be easily localized. Today, that framework is being tested to its limits. It is important, therefore, to appreciate the relevance of intellectual property in the contemporary digital environment. In the past, creativity was confined largely to specialized domains. Authors, artists, inventors, and manufacturers. But in the digital age, every person with access to a smartphone or a computer becomes a potential creator. Posting original content, writing blogs, sharing music, designing digital art, or developing mobile applications. The very act of expression has become an exercise of intellectual creativity. Yet, with this empowerment comes the risk of misappropriation. Every image uploaded, every line of code written, and every video shared online become susceptible to duplication, manipulation, and unauthorized monetization. This makes understanding of intellectual property laws not just a matter of legal compliance, but a matter of personal and professional protection. The modern era is characterized by unprecedented digital transformation. Every sector, commerce, communication, education, healthcare, entertainment, and governance, has been reshaped by the advent of technology and the pervasive influence of the internet. The virtual world, or say cyberspace, has become an integral part of everyday life. It connects billions of users, allowing the seamless flow of information, ideas, and innovation across the borders. However, this rapid expansion of digital domain has also brought forth complex legal and ethical challenges, particularly in the field of intellectual property rights (IPR). The intellectual property, once confined to tangible works of art and invention and designs, now extends deeply into the digital sphere. Every digital creation, whether a photograph, a song, a video, or even a computer program, is an intellectual product deserving protection. Yet, the ease with which digital content can be copied, altered, and redistributed without authorization has made the cyberspace a breeding ground for infringement. The traditional framework of IPR, developed in an era of physical exchange and territorial enforcement, are now struggle to cope with this borderless, instantaneous nature of online transaction. The intersection of intellectual property and cyberspace represents one of the most dynamic and challenging areas of the contemporary legal study. In the digital economy, ideas and expressions and innovations are the primary drivers of value. Protecting them is not only a matter of law but also of economic growth, technology progress, and cultural preservation. Understanding IPR in cyberspace therefore requires examining both its relevance and the transformations that have redefined its very scope in the digital age. The digital revolution and its impact on intellectual property. The evolution of digital technology has fundamentally altered the landscape of creation and dissemination. The shift from physical to the digital mediums has made creative works easily replicable, transmissible, and modifiable. A single click can reproduce and share an image across continents. An entire film can be downloaded or streamed illegally within minutes of its release. These phenomena have challenged the conventional mechanisms through which intellectual property rights were protected and enforced. The digital revolution has democratized access to creative tools. Anyone with the internet connection can create, publish, and distribute the original works to a global audience. While this democratization has empowered individuals and encouraged creativity, it also diluted control over intellectual ownership. Content can now be decontextualized, remixed, and monetized by others without the permission, often without the original creator's knowledge. The very qualities that make cyberspace innovative, its speed, reach, and openness, also makes it vulnerable to misuse. As a result, intellectual property protection in the digital environment is no longer limited to safeguarding the tangible works but extends to data, algorithms, databases, softwares, online branding, and digital performances. The transformation from a goods based to an information based economy has made intellectual property a crucial determinant of economic success. Nations and businesses compete for not only for the material resources but for the intellectual assets and technological superiority. Thus, the safeguarding of intellectual property in cyberspace has emerged both as a national and a global priority. The relevance of IPR in the knowledge economy. The 21st century is often termed as the knowledge economy, where ideas, creativity, and innovation form the backbone of the development. Intellectual property rights provide the essential legal infrastructure for this economy by granting creators the exclusive rights to their work, ensuring recognition, and providing financial incentives for further innovations. In a digital ecosystem, these rights acquire even greater significance because almost every form of communication and commerce involves intellectual content. In this interconnected world, digital products ranging from ebooks and streaming content to mobile applications and virtual goods are traded, licensed, and consumed at an unprecedented scale. However, as digital content becomes ubiquitous, so does its unauthorized use. Online piracy, plagiarism, domain squatting, and counterfeiting have become pervasive, threatening the sustainability of creative industries. These practices not only undermine creators' rights but also distort the markets, reduce government revenue, and discourage innovation. Therefore, intellectual property protection in cyberspace is not a mere legal concern. It is an economic and developmental imperative. The effective IP enforcement builds trust in digital markets, fosters investments, and promotes innovation-driven entrepreneurship. Without it, the digital economy risks dwelling into a space where creativity lacks value and originality loses its meaning. Cyberspace, a borderless and a complex legal domain. Unlike physical territories, cyberspace transcends national boundaries. A website hosted in one country can be accessed from anywhere in the world, and a digital transaction may involve multiple jurisdictions simultaneously. This borderless nature complicates the enforcement of intellectual property when an infringement occurs online. Determining the applicable law, identifying the infringer, and enforcing the judicial remedies become formidable challenges. For instance, if a copyrighted film produced in India is illegally streamed from a server located in another country, the victim faces a tangle of jurisdictional and procedural barriers. Question arises regarding which nation's law may apply, where the suit should be filed, and whether a court orders can be enforced across the borders. The absence of a unified global regulatory system makes cyberspace both powerful and perilous. Anonymity further aggravates the problem. Users can hide their identities through virtual private networks, VPNs, proxy servers, or false digital credentials, making it difficult to trace infringement. As a result, even when violations are detected, securing justice is neither simple nor swift. This reality underscores the urgent need for international harmonization of digital IP laws and enhanced cooperation among the enforcement agencies worldwide. Technology, the double-edged sword. Technology serves both as an enabler and the disruptor of intellectual property protection. The same tools that empower creators also empowers infringers. Advanced editing softwares, digital manipulation tools, and content sharing platforms make it easy to reproduce or alter the creative works without authorization. On the other hand, technological solutions such as digital watermarking, encryption, blockchain verification, and automated content monitoring offer innovative ways to safeguard the ownership and trace infringement. This duality reveals that legal mechanisms alone are insufficient to protect intellectual property in cyberspace. A holistic approach combining law, technology, and awareness is essential. While legislatures and courts strive to modernize IP laws, technology-driven enforcement and public education must complement the legal measures. Encouraging a responsible digital behavior and ethical online practices is as crucial as statutory protection. The economic and societal stakes. The economic implications of digital IPR infringement are vast. Global studies indicate that creative and IP-intensive industries contribute a significant portion of GDP in most economies. These include sectors such as software, film, publishing, design, biotechnology, and fashion. However, their outputs are illegally copied or distributed. The losses are staggering both in terms of revenue and employment. For example, online piracy in entertainment sector deprives filmmakers, musicians, and distributors of legitimate income. Similarly, counterfeiting and e-commerce not only erodes the brand value but also poses safety risks to the consumers. Small businesses and startups which rely heavily on digital branding and innovations are particularly vulnerable to such infringements. In a larger sense, IP violations destabilize digital markets by undermining trust between the creators, consumers, and platforms. From a societal perspective, the misuse of intellectual property also raises ethical concerns. In many online communities, sharing and copying are normalized behaviors. Users may not perceive downloading an unlicensed movie or replicating digital artwork as theft, leading to a culture of casual infringement. This shift in perception reflects an ethical dilemma as to how to balance the principles of free access to information with the rights of creators to control and benefit from their work. Thus, the relevance of IPR in cyberspace extends beyond economics or legality. It speaks to the values of fairness, respect for creativity, and social responsibility. Protecting intellectual property is not merely about enforcing ownership. It is about sustaining the culture of innovation and ensuring that the creative labor continues to be rewarded. Globalization and international dimensions. Globalization has magnified the significance of intellectual property protection. The digital environment enables the instant transmission of content across the borders, turning social works into global commodities. However, the same transnational flow of information exposes the intellectual property to worldwide infringement. International organizations such as World Intellectual Property Organization (WIPO) and the World Trade Organization (WTO) play central role in fostering cooperation and standardization. Instruments like TRIPS agreement, that is trade related aspects of intellectual property rights, sets a minimum global standard for IP protection. Yet, despite these frameworks, variations in national laws, enforcement mechanism, and judicial efficiency persist. These differences often create loopholes that infringers exploit to evade accountability. Moreover, the rise of global digital platforms such as social media networks, e-commerce, marketplaces, and streaming services has blurred the boundaries between the local and international law. Platforms must navigate multiple regulatory regimes simultaneously, and creators often struggle to secure consistent protection for their works worldwide. Thus, a key component of modern IP policy involves harmonization and transnational enforcement. The Indian context. In India, the growth of cyberspace has become phenomenal. With one of the world's largest digital population and a booming tech industry, India has emerged as a hub for online innovation and creative enterprise. The expansion of e-commerce, OTT platforms, digital media, and startup ecosystems has made intellectual property more relevant than ever before. However, the rapid digitalization of society has also intensified the challenges related to IPR infringement. Unauthorized reproduction of software, illegal streaming of movies, online sale of counterfeit goods, and misuse of trademarks are the widespread issues. The Information Technology Act 2000, along with Copyright Act 1957 as amended in 2012, and also the Trademark and the Patent Related Acts, provides a legal framework for addressing these concerns. Indian courts have in recent years adopted a proactive stance in recognizing and remedying the digital infringements through injunctions and enforcement orders. India's commitment to international treaties such as TRIPS and membership in WIPO underscores its role in the global IP ecosystem. Yet the enforcement gap remains significant. Awareness among the creators, consumers, and digital intermediaries is limited, and technological expertise in cyber forensics is still developing. The strengthening enforcement agencies, enhancing interagency cooperation, and promoting IP education are crucial for safeguarding intellectual property in India's cyberspace. Balancing protection and access. While protecting intellectual property, it's crucial that overprotection sometimes hinder the free exchange of ideas and stifle innovation. The challenge lies in maintaining a balance between exclusive rights and public access. The internet thrives on openness and the sharing of knowledge, which have catalyzed and unprecedented global learning and creativity. Overly rigid restrictions could curtail this openness, especially in education, research, and public interest contexts. Therefore, intellectual property frameworks in cyberspace must evolve to protect creators while also facilitating access to information. Mechanisms such as fair use exceptions, open licensing models, and Creative Commons frameworks exemplify how law can adapt to digital realities. Encouraging innovation while preserving public interest remains the guiding principle of modern IP policy. The emerging technological landscape. As digital technologies continue to evolve, new forms of intellectual property and novel challenges are emerging. Artificial intelligence now creates artworks, composes music, and writes codes. The advent of non fungible tokens (NFTs) has transformed ownership and trade of digital assets. Virtual and augmented reality environments, including the metaverse, have redefined creative expression and commercial interaction. These innovations raise profound legal questions. Can AI generated work be copyrighted? Who owns a virtual asset sold in the metaverse? How do existing IP laws apply to decentralized blockchain based systems? These debates indicate that intellectual property law must continuously evolve into the relevant digital age. The future of IPR in cyberspace will likely to involve a fusion of legal adaptation, technological innovation, and ethical governance. Conclusion. The digital age has revolutionized human creativity and communication, but it also destabilizes traditional notions of ownership and protection. The intellectual property rights form the backbone of the digital economy, safeguarding the interests of creators and innovators in an era defined by speed, connectivity, and constant transformation. Cyberspace, by its very nature, challenges the limits of jurisdiction, enforcement, and control. Protecting intellectual property in this borderless domain requires more than laws. It requires awareness, technological advancement, international collaboration, and ethical responsibility. The goal is not merely to prevent the infringement, but to create an ecosystem where creativity and access coexist harmoniously. Understanding the overview. Thank you.